Hello and welcome to Argumentor podcast. In this session, we have with us Ritwik. He's not new to us. He's coming for the second time, especially with regard to a very important topic at hand. And this is especially with regard to the labor laws in our country and how it supposedly is being diluted or is it being amended with regard to taking into note the current prevalent situation as such. So I'll just be driving a few key points with regard to how we would be moving on with this session. So basically, I think the two of you must be already knowing about the latest news of this company called Kitex also, which was in Kerala, and it had to move its shop to Telangana because uh, allegedly the government was being too bullish with regard to their reports on several violations by the company. Though the left government might seem to be a little more pro-labor, but then they're always against so-called bourgeois side. But that aside, um, with the current context of wages and also with regard to several aspects of working hours and different aspects as that, do you think it's a viable situation while we are going ahead? Like what we're going to be talking about is also several states in particular, like in Uttar Pradesh and Madhya Pradesh, how they have brought about changes in their industrial laws, especially with regard to wages, with regard to the working hours, and with regard to even exemption as well. Or is it actually a misplaced fad that Uttar Pradesh has actually completely removed of the application of labor laws for at least 3 years? So how's the entire situation at hand right now, Ritwik? So if you could just briefly tell us as to how important these labor laws are, and also what is being why is it being changed in the first place? Is it because that it's COVID and require more investment as such? That's the reason why we are trying to change the entire laws, or what is the basis at which we're looking at it?
So again, very good morning to all, and again a very good opportunity to be on the platform of Argumentor for the second time. And right, so when we speak about the current dilution of the labor laws, which began in 2020, let's get on with a brief overview of why the dilutions actually took place. What was the background behind those dilutions? So now, if we look at 2020, the advent of COVID-19 global pandemic, the working class was one of the most affected sections of the society, and a plethora of problems arose for the workers, especially those who had migrated to other regions to search for a livelihood. Right. Now, the sudden imposition of the nationwide lockdown actually meant that most of the economic activities, including some of the essential activities, were shut down, at least temporarily. And this majorly impacted the country's overall economy in the times of a heightening health crisis. And that was the case with most of the countries around the world, right? Now, when we look at the newspaper reports or the media reports from that time, they unanimously reported the loss of income for and opportunities for several people, specifically the working class, due to the suspension of various economical actions and workings. So the intention behind the dilution of the labor laws was to cope up with the situation of an economic downfall, and therefore the various states, Uttar Pradesh, Madhya Pradesh, Karnataka, relaxed their respective existing labor law policies and arranged for an increase in working class, or arranged for an increase in the workforce and the working hours by the way of notification and ordinances. So the basic intention, to reiterate what I just said, the basic intention was to cope up with the economic downfall, and they thought that by increasing the labor force, by increasing the working hours, by modifying the labor union rules and regulations, by modifying the overtime wages, by modifying the number of hours a person, a woman, or a child can be employed. So they thought that by modifying all these things and adding some new provisions and deleting something else, they could deal with the economic downfall, which Indian economy was going through at that time, and it is still going on right now as well. So that was the basic intention behind the dilution of labor laws. So before we go ahead and say or deliberate upon the fact that whether or not these dilutions were constitutional, given the judicial backdrop of labor law regime in India, let's first focus on the fact, very briefly that too, that what exactly is the purpose of these labor law legislations. So for in India, if you say, so there are a plethora of labor law legislations, and there is an increasing demand that these, labor laws should be codified into some specific codes, right? So there is Factories Act, Employees Compensation Act, then the Provident Fund Act, then the Payment of Bonus Act, etc., etc., etc. So
like all those things as well.
it's exactly, and Industrial Dispute Act. So I mean, Joel and Minaj, you will be studying all these things, as your core subjects in the upcoming 2 semesters, in your fifth and sixth semesters. So stay tuned for that. It's a bit repetitive and bit boring, but a bit exciting at the same time. So now let's focus on the fact that why exactly the labor legislations came into place, the evolution of labor legislation in India. So labor law in general, if you look throughout the globe, was the result of workers' demand within the working premises that, our employers should meet our reasonable demands and stuff, and the corresponding request of the employers for restricting the authority of the worker group and reduction of labor costs. So the employers were like that, fine, we will, secede to the reasonable demands of the working class, but at the same time, there are workers groups and all within the workplace, so their authority should be restricted and labor costs should not go too high. So just to sum it up, labor legislation, when you talk about it, satisfies, or it seeks to cover up three critical objectives. First of all, it builds up an overall set of laws that works with the useful individual and aggregate business connections. Secondly, it acts as a crucial instrument to set up agreeable and democratic nature of trade unions for offering a structure inside the workplace wherein the businesses, the employees, employers, and their agents may negotiate on the labor problems. So to, plainly say, to deal with the internal matters of a particular workplace. And the third one is, it provides a consistent update and assurance that the basic principles of the workplace for both the employers and the employees will be held up, and it also sets up the the cycles, the structures through which the basic standards and rights can be executed and implemented. So these are the three basic objectives of labor legislations, not just in India but throughout the globe, right? So now when we talk about the pandemic situation, when it all happened, how the dilution took place, regulation of wages, industrial relations, and thirdly, occupational safety, health, and social security. So these were the three major codes, which were given the presidential assent so as to modify or relax the existing labor policies in our country governing the workplace, governing the labor connections, salaries, the procedures, structures, etc., etc., etc. So now, when we speak about those codes, those ordinances which were given effect, when we speak about Madhya Pradesh, when we speak about Uttar Pradesh, when we speak about Karnataka, or any other state which relaxed their respective labor policies. So there are four major common points which were in all those, legislations, or which were either expressed by those codes or was implied by those codes. Yeah, so these 4 points were,
especially like, just to cut you through, like especially like if you go and see the UP ordinance. So if I could just move you to the UP temporary exemption from certain labor laws ordinance, and if you look at section 3 in particular, like there are certain conditions wherein it clearly states that all factories and establishments engaged in manufacturing process shall be exempted from the operation of all labor laws for a period of 3 years. So, like with regard to how valid is that with regard to the that in place, and what the condition is it's asking for is that there needs to be name and details as in electronic format according to the Factories Act. Then you can't be paid below the minimum wages as per the government of UP, and also the time limit as well with regard to the workers shall be paid, and also they should be paid on their bank accounts, and they can't be allowed to work for more than 11 hours per day. and all the other kind of aspects of if they die in the course of their employment, or with regard to their provisions for children as well. So these kind of conditions are there, but regarding how, like, see, we completely understand that because of the COVID, we had huge amount of economic loss as well. So in all, like, it is unfortunate that a state of Kerala has lost out its investment with regard to Kitex, but a state of UP or a state of Madhya Pradesh might try to gain, or example, Telangana gained out of what Kitex did to move to Telangana. So with regard to UP or other places, don't you think it's a more since these states are pretty much economically backward, the relaxing of these labor laws can actually enhance their economic process and economic gains, increasing the employment, but also sacrificing or kind of cutting down on their several factors of social security, and also working hours, and also general human health in particular in these working times. So don't you think that that's a more plausible argument when you look at it than looking at it as to how these ordinances can affect in the future as well?
And also, if I could add on to Joel's point, Ritwik, you know that most labor laws in every country also heavily focus on the welfare of laborers, because labor is the life force of every economy in every country almost throughout the world, especially in developing economy like India. So don't you think the dilution and temporary suspension in certain areas of these labor laws would lead to a lack of welfare of laborers, and over time would sort of derange the efficiency of labor? What are your views on that?
Right. So, yeah, very well said, both Joel and Minhaj. The argument which you laid out, that yes, some social security provisions may be circumvented, but it can be compensated with the economic growth and stuff. Right. Now, when let's draw a parallel with the Factories Act. All right. So one of the major things that this labor law dilution resulted is the subsumption of many core provisions of the Factories Act. So if you look at the Factories Act section 11 to 20, specifically it deals with the provisions related to the health of the workers, and section 21 onwards, the safety and the security in the workplace. Now, when you speak about economic growth, right? Definitely workers or the workforce, general workforce or the general labor force, it's, very much, pertinent that those people will play, or those sections of people will play a major role in, increasing the productivity, increasing the, output for that matter. And it is reasonably expected that growth in output is equal to growth in revenue, income through imports, exports. However, when you look at the Indian market, right? So Indian market, if you look at it, isn't really affected by the productivity per se. The major factor why the Indian products have not gained a strong foothold is more related to their quality. So some of the products which have a really good quality, such as the Kanjivaram silk sari or the Banarasi sari and some other products like that, they have a strong foothold in the market from a very long time. Why? Because their quality either have remained the same or it has increased. Now, this is not the same case with the other, sections of products or manufactured goods, etc. So when you say that you increase the workforce, it will increase the economy, it may increase the productivity, it may increase the output, but it does not assure you a good quality of product. It does not assure you that. And secondly, now let's go back to our Factories Act. So if you see section 16 of the Factories Act, which deals with the overcrowding provision in the workforce. So and in the section 16, it is given that for ensuring proper health of the people working in a particular workplace, whether it be an industrial establishment or a factory or any other establishment which deals with economic dealings and all. So there has to be a 14.2 cubic meters gap between the workers. So, and it also includes the provision of dust and fumes, ventilation, water, spittoons, latrines and toilets, etc., etc. Now, let's say that, as per the old labor laws, there is a factory A and Minhaj and Joel are employed in that, and everything is going fine according to the provisions of Factories Act, right? So everything is going fine. Now, this particular dilution of labor laws, now let's focus on UP only, or MP or Karnataka for that matter, which increases the threshold of the employment of workers or employment of laborers for that matter. So now what happens? The state government has the authority to increase the workforce with the thought that this will increase the productivity and it will increase the economic activity, economic growth as well. Now, just think about that. Now 200 more people are coming in the same workplace with the same security same security structure, with the same amount of resources available for benefits of the workforce. So now, apart from Minhaj and Joel, there are 200 more people. So definitely there will be overcrowding, the ventilation will be curbed, the other facilities which are there for the benefits of workers will also be curtailed, because the supply is less, the demand is more. So there is the demand supply gap there. So now when you speak only about economic activity, understand that when the labor legislations are drafted out, for example, the Maternity Benefit Act, when it's drafted out, what does Maternity Benefit Act provide? That a woman who is pregnant can take some leave from the job where she is working and she can get paid for that period of leave, right? Now, understand, the woman is not working at that time. The woman is not working at that period. So there is no economic activity. Then why is she being paid? Because it is focusing on the welfare of the woman as well, which is very important, because the intention behind the legislation is, the legislation is, once the woman comes back, she can be supported in all the ways she can, so that she can regain her previous capacity when she was not pregnant, right? So that was the intention of the legislation. So now when you dilute the labor laws and you do not provide specifications as to the increase of the social security measures and benefits and the other things for the welfare of the labor force, somewhere or the other, you are, compromising with Article 21 and Article 23 of the Constitution. Because if you look at the cases of Maneka Gandhi versus Union of India, or Francis Colliery versus Union of India, or in the case of labor law, Bandhua Mukti Morcha versus Bandhua Mukti Morcha case. So there, what did the Supreme Court expressly lay down? Right to life includes right to live with dignity, first of all, and the dignity includes a good health, nutrition, and such a working environment which does not circumvent with your health. So as to plainly put, if you won't live, agar zinda hi nahi rahoge to kaam kya karoge? So something like that. If you are not fit to work, what will you work? So doesn't make sense that these state governments or the central government, the intention was good. Surely the objective was good, to promote economic growth, but enough deliberation was not done. And, the supplementing factors which are useful, which are useful for the benefit, which are useful for the welfare of the labor force, that was not done. So just to summarize the four major points, which was common in all the ordinances, UP, MP, Karnataka, etc. So the first one was these 20 bills, they raise several thresholds. First of all, they raise the number of workers to be employed so as to make them fall under the purview of the ID Act or the Factories Act, etc., both in the terms of salaries or retrenchments or layoffs. So the threshold of the people to be employed is raised. Somewhere where it was earlier 100 workers, now it is 300 workers. Secondly, they, as Joel mentioned when he was making his point, secondly, they provide the government with the power to exempt establishments from any or all of their provisions, right? So the Code of Industrial Relations govern the working conditions, trade unions, dispute resolution. Now the government has the authority in public interest to exempt any new industrial establishment from the provisions of this code. Now understand the implications here. So suppose if if there is an industrial establishment which is just evolving, which is just growing, which has a good potential ahead it, but sadly, as per the 2020 criteria, it doesn't fall under the Factories Act or ID Act or any other specific act, then that particular industrial establishment will be left up from the statutory framework, and then the government would require only the employers to take decisions as they deem fit. Now, this has the long-term implications for those establishments which are just evolving, which are just growing, and it also has problems for all those establishments which have already set up their brand name, because now they are like, if we do not employ more workers, if we do not provide them with a minimum wage, or if we do not circumvent the social security provisions to a certain extent, we won't be covered under this act. Now, understand the implications it has for the employers in terms of the costs, the labor costs, and the employees in terms of the social security thing. And as I said earlier, it is not exactly the quantity which matters, but the quality, right? So if you have employed a lot of workers, but you are still not able, if you have employed a lot of workers and you come under the purview of all these statutory frameworks as per the 2020 codes and all, but still you are not able to give up quality materials, quality manufactured goods, what is the point? I mean, even though there is increased productivity, but the import export will be affected because no one will be wanting to buy your substandard product and all, right? Now, the third one is there are changes in contract labor. This Karnataka Karnataka code specifically deals with some amendments to ID Act, Factories Act, and the Contract Laborers Act. So the contract laborers, the threshold has again been increased so as to bring them under the Contract Laborers Act. And secondly, the contract laborers are now said that don't engage them in the core activities, engage them in some supplementary or complementary activities, don't engage them in the core activities. And finally, and one of the most contentious things are, if you look at Factories Act, they provide a specific time for the women to work in the factory or other establishments, and the same specific number of hours are given for children, and specifically the girl child, right, who is below 18 years of age. So now these new things, these if you want me to be specific, then the occupational safety bill allows the 2019 occupational safety bill allowed the government to prohibit the women from working in some detrimental or dangerous activities, but the 2020 bill is like, employ more and more people, they can be women. So now the working hours of women have increased, the time period, which earlier it was, I guess, 6 a.m. 7 a.m. to night ka 8 p.m. something. Now it's like 6 a.m. to night ka 1 p.m. So the hours have been increased. Now the women can be employed as per the whims of either the state government or the employers. They can be engaged in all the dangerous activities as well. So now, I think
in the UP one, it is mentioned that the provisions of the various labor laws relating to employment of children and women shall remain applicable. So maybe I'm not sure if in particular context of women and children, it's still changed as such. Don't you think so?
Right. When they say that, okay, it will remain applicable, the thing is, many things are being said, but what is the actual reality? Does every single establishment in a state like UP, where the area is more, the population is so much, so, and plus understand this, the 2020 bills do not provide for, in nowhere they provide for the inspection of the establishments, the factories or other industrial establishments. So they do not provide for an express provision for inspection. They are not in consonance with the ILO Convention 81. So there is no inspection, there is no monitoring, there is no grievance redressal mechanism. Also, the trade unions and the other workers groups have been circumvented for the time being, in the public interest only, that don't protest and all. Otherwise, we won't be able to employ you more, and therefore we won't be able to increase the productivity. So that's their, logic. Now, the thing is, although the, UP code says that all the major provisions, the core principles of the labor legislations and labor policies in India will be upheld, but, to what extent are they upheld? What is the reality? Is it reasonable to assume that A to Z, if there are 100 establishments in UP, for example, all the 100 establishments, will agree to, function according to the labor policies and all. It is not reasonable to assume that. Why? Because first of all, there is no monitoring, there is no inspection of such institutions. And once these institutions or establishments go unmonitored, they are mostly upon the whims and fancies of the employer. And understand, these workers we are talking about, they are illiterate. They don't know the technicality of these. They don't know. They are, if we have to speak, they are not aware of their basic rights in a workplace. It is the duty of their employer or the duty of the government to make them aware. So unless and until proper awareness camps have been, set up for making the people aware about the specifics, and the employer does not take reasonable steps in that accord, so now we can assume that the workforce will remain unaware of their basic rights, and therefore they will be like, working as per the orders of the employer, and they have to work because right now they don't have any money available, they don't have economic support available, so they have to work according to the whims and fancies of the employer. So although the bill says that, okay, we will provide this, are those things actually provided given the population of the state and given the labor establishments and all are not monitored regularly? Even in normal times they are not monitored. Understand these times, so now when you speak about it,
just to cut you there, if you remember, before the 90s, there was the entire inspection Raj, license Raj. So it was pretty difficult for factories and establishments to set up in India because there's a lot of checking and a lot of conditions and regulations as well. So it is a fair point that the provisions about inspecting and monitoring these particular aspect of violations being done is a valid point. But also several industries can also move out or not set up shop in India or in that particular state because of these conditions, if it was so met. Like if it was present at that particular place, or if there's excess amount of inspection or this kind of human right kind of reports excessively coming closing down on them, they may just consider not setting up their shop in the particular state, and may set up in a more investment friendly state or investment friendly country as such. So isn't that maybe that's one of the key points what the industrialists might put forward as well, right?
Right. But I think when you look at this point, if I may add, it's basically like Ritwik tried to enunciate as well. It's like exploitation on the garb of legislation. You can look at it that way, because the employers are going to obviously take advantage of this information gap between them and the employees and try to exploit them because they're hungry for work and hungry for income for themselves. So taking advantage of this, there has to be some sort of inspection that has to take place so that these measures are at least kept at a standardized level. And otherwise it would lead to large-scale exploitation. And as like Ritwik mentioned as well, many of the trade unions have been subdued by the governments in order to increase the productivity of the labor, in order to increase the production capacity in these factories.
Even the trade unions have also been deterring on some, they are like, sometimes they get too excessive on the factory to obey their rules and with regard to employing these people. Or
I'm not talking about the crux of what they're trying to do, but if you look at it at a general level, that's the main purpose of this whole intention, right, of this legislation, to increase productivity, and it subdues certain parts of other labor legislation that allow the employers to get the upper hand. And I think that's the point Ritwik was trying to make, if I got you wrong.
Okay, just to reply to Joel's point about the committees and stuff. So sure, if you look at it, there was license Raj, there was some difficulty in investment and productivity process in the 80s, 90s, etc. Now, however, if you draw a parallel to the prevention of sexual harassment at workplace, it's not related to labor law per se, but I'm just saying, see, in that particular act, in the Prevention of Sexual Harassment Act, there are provisions for an internal complaints committee and a local complaints committee. If I'm not wrong, it is section 4 and 5 respectively. If I'm not wrong, I can't remember it correctly. So now let us look at it in this way, and it may be one of the recommendations as well. Now, since the trade unions have been circumvented from their normal activities of protest or of strikes, etc., because of the excuse given is of public interest, productivity, etc., etc. So all right, fine, the trade unions may be circumvented and all, but when we look to monitor a particular industry's activities and all, so it can be done that the employers, or for that matter even the government, can order that at least have an internal committee, for inspection. The members can be one impartial third member, which who is well versed in labor law matters, a scholar or an academician for that matter. It can also be a district court judge or a good paralegal, right? It can also be a proper government servant like a retired DSP, DIG, etc., etc. It can also, that particular committee can also include one or two eminent people from the labor force, who the laborers say that, okay, if there is a labor force and Joel, you are our representative, so you will be in that committee. So all of them would try to internally locate the problems, internally locate the discrepancies between the productivity criteria and the social security criteria, and then give suggestions internally. They don't have to go to the court. They can give suggestions internally, negotiate, then maybe apply some conciliatory factors, and then they can carry on with their work. So that can be done. However, such an order about an internal committee as well have not been given by the government expressly. And again, since employers in this era of globalization, mostly they are profit oriented, therefore they will, it can be expected that they will take the advantage of the situation that the laborers don't have work. They will take advantage of the situation that the government has diluted the labor laws for the objective of gaining economic growth and productivity. And they will also take the advantage of the persisting economic gap between the majority of workers and the employers, who are much more well versed in the industrial, if you say legal framework or legal scenario. So these advantages, if taken, then the labor force or the workers or the workers organization will be, facing undue or unreasonable exploitation. So let's look at some of the important judicial pronouncements of the Supreme Court in the labor law regime of India. So PUDR versus Union of India, then Bandhua Mukti Morcha case, all of both these cases specifically said that the forced labor should not be there. There should be no bonded labor, because it straight away violates Article 23 of the Constitution, which is a fundamental right. So there is a right against bonded labor, and whatever labor you do, you have to be remunerated in a just and reasonable manner for the same. Again, when you look at Randhir Singh versus Delhi administration case, so there the case said, there the Supreme Court said that unless and until the trade unions are being absolutely unreasonable, unless and until that unreasonableness happen, the trade unions do have the right to protest, to voice their opinions, needless of the situations, because they represent the overall benefit, the overall security, and the overall quality of life and work of the workers in a particular establishment. And then when you look at the Sunil Batra case, the Supreme Court said that right to health is an essential part of right to live with dignity. And now let's gel it up with the current provisions of the bills. So there is a increased threshold of working hours. There is an increased threshold of the number of people employable in a particular industrial establishment or a workplace. Now, what does that mean? Since there is an increase in the number of hours, since there is a circumvention of the overtime pay provisions, and there is a circumvention of the fact that the health, the social security, and other beneficiary parts of the legislations to the workers under the Factories Act or the ID Act, and also the dispute resolution provisions are being circumvented. What does that mean? Now the workers are being employed to just increase the productivity so as to enhance the economic growth, but again due care is not given to their health and well-being, which ultimately affects their right to life, and by extension right to life with dignity. So when we see these major judicial pronouncements, what they held briefly is that under no circumstances, unless and until it's a national or a state emergency, unless and until, or a financial emergency for that matter, so unless and until the emergencies, the constitutional emergencies happen, the fundamental rights, especially the right to life, which has, received the broadest interpretation in Constitution. So specifically that right, and also the relevant rights such as Article 19, if you speak about right to freedom and expression, or right to form associations, right to, voice your opinions through that particular associations, and Article 23, right against bonded labor or forced labor, etc. So unless and until a constitutional emergency is in place, unless and until that happens, you cannot circumvent or do away with the fundamental rights of the people, even in public interest. And again, understand that
just to ask you a question, can COVID be treated as a public emergency? Because under the Factories Act, if you go to Section 5, it states that with regard to powers to exempt during a public emergency, like in case of a public emergency, the state government may by notification exempt any factory or class or description of factories from any of the provision of the Act, except for in the case of employment of young children below the age of 14 as such. And so as such conditions shall may think fit. And a public emergency, it's mentioned that it's a grave emergency, especially with regard to security of India or a threat, internal disturbance or external aggression. So can the justification put forward by the state government that at a COVID is a public emergency and hence there can be the powers to exempt from such provision of the labor laws be put in place, and especially with regard to the Factories Act and also with regard to the ordinances in place?
No, I think the answer is no.
If I may add on.
Sure, Minaj, go ahead.
I think the problem there is we're discussing and deliberating on fundamental rights here, and fundamental rights cannot be suspended in whatsoever manner, except for under the constitutional emergencies that you mentioned earlier. So even if there is a public emergency that is declared, it only affects the provisions mentioned in the Factories Act, but not the fundamental rights of the whole.
Like Factories Act, especially with regard to the working hours, especially with regard to those, like during the course of employment, there can be certain amendments made. So even with regard to weekly hours or what they've given is that you can still, like even with regard to work time and stuff like that, the total number of hours cannot exceed 12 hours and stuff like that, especially under the Factories Act. So especially if there's an emergency in place, can the COVID be treated as an emergency so that the state governments can subsequently make amendments into the labor? That may be a prior reason why UP has tried to exempt them for 3 years, because the economic condition has been so bad, especially during COVID.
COVID can at most COVID can be considered as a public and an escalating health crisis, but not an emergency, because the necessary conditions for an emergency is clearly enunciated in the Constitution. For national emergency, Article 352, you just said external aggression, internal disturbances, and the integrity and security of India. For state emergency under Article 356, it's when the constitutional machinery of a state is not functioning as per the the constitutional provisions. And again, for a financial emergency, it's the threat to the credit, the overall credit of India, right? The credit score or the credit, the economic credit transactions of India. So now this coronavirus pandemic, although is a health crisis, but it cannot be treated as a pandemic because it doesn't fall in the purview of the 352, 356, and 360. So now when the they are treating it as an emergency and stuff. So for proclamation of an emergency itself, there is an extensive procedure of laying down the bills between both the houses, getting the assent, getting the simple and special majority, and the ratification of states and all. That's a comprehensive process. Now, suppose if the governments are treating coronavirus as an emergency, understand that they have not, followed the constitutional provisions for declaring an emergency or to declare that this particular thing is an emergency. They have not followed the procedure for declaring the emergency. The constitutional procedures are not being followed. Therefore, also, it is the second reason why coronavirus, although very unfortunate and although an pandemic, cannot be considered as an emergency, and the fundamental rights by extension cannot be suspended within it. right?
Maybe
Because
that is
it's not
why,
enough.
yeah, maybe that is why they introduce it as an ordinance instead of a usual act. So because for an ordinance, especially when the house is not in session, so without the consent of the legislature, you can bring forward an ordinance, but then it has to be made into a permanent act in some time, especially with the assent of the president. So maybe that is the reason, one of the key reasons why it was brought forward as an ordinance as such.
Yeah, sure. I mean, surely the thing is, it is an ordinance and not an act, because in any way, the proper deliberation, the extensive deliberation before, making a particular bill an act was not done in this case. So surely it's, in the manner of a code, sure. But the thing is, although maybe for 1 month or 2 months, this code can remain in place and they can expect, okay, the workers will be like fine with their rights being circumvented because they're getting money in return, and they are fine with the social security and other welfare provisions being circumvented as per the whims and fancies. But again, it is not feasible for a long term. We do not know when this coronavirus thing will, do not know that how long will the productivity or the overall economic condition of our country will be affected. We do not know that what would be the exact time period which will be taken to keep this particular economy in a position where it was back then before the coronavirus thing. We do not know. We can only make assumptions. Now, the problem with assumptions is, if you are continuously making assumptions, the workers are still working. They have not stopped the work. The productivity is still going on. They have not stopped the manufacturing of the products. They cannot afford it. But now understand, there is an uncertain time period for everything. The future is uncertain. Now the workers are being like, okay, the future is uncertain, you keep on working. So all these labor provisions, all of this have been diluted, although they are stated to be temporary in official language. But again, how much temporary, till what time will this go on? And suppose if it is still going on right now, so right now various measures have been relaxed and all that. In other states, the lockdown measures also have been relaxed. Even in your area, I will assume reasonably. So now is the time. If they are saying ki we are continuing this thing for public interest, for economic growth of the country, now is the high time that the government include some of the beneficial social measures or monitoring or other mechanisms for the benefit of the workforce, which is still working in these times, right? So as to spare them of some uncertainty and say ki, although the future is uncertain, although we require you to work like you are working, but here, take some beneficial mechanisms for your aid, for your benefit, because we are bothered about the quality of life for the workforce. That can be done, which has not been done yet expressly in many states, right? Especially not in Uttar Pradesh, because again, the population, the lack of information, etc. So here we see that if dilution of labor laws is not accompanied with some beneficial provisions or beneficial steps taken for the workers right now when the situation is a bit relaxed, right? If it is not taken, then it would again amount to a blatant and unreasonable violation of their fundamental rights, which is in no circumstance justified, right? Now, when we speak about recommendations in brief, so just what I said, and Minhaj and Joel, you both also enunciated in certain parts of your speech, that now is the high time that these codes should be revisited. The CAA and RC code has been revisited. It is the bylaws, regulations are coming up. We discussed this earlier in the previous session. Yeah. So now is the good time to revisit all these codes, draw a parallel with the constitutional regime, draw a parallel with the Supreme Court judgments and the judicial precedents in the labor law regime particularly, and then vis-a-vis Article 253 of the Constitution, which deals with the international treaties and all. So vis-a-vis Article 253 and ILO conventions, specifically Convention number 81. So all those conventions, all those relevant treaties, along with the UDHR and ICESCR, and the Constitution of India is already there. So all those analysis have to be done. Now is the high time. They have to be done. They can be done so as to provide the workers with some benefits for them as well when the future is extremely uncertain. So again, to sum up the recommendations, First, revisit all these codes. Second, draw a parallel with the existing constitutional machineries and the judicial precedents in the labor law regime. Third, draw a parallel with Article 253 of the Constitution, ILO conventions, and relevant international treaties on labor law and welfare, including ICASCR and UDHR. And fourthly, analyze all of them and then come up with the beneficial points or beneficial structures or beneficial mechanisms, so that the fundamental rights of the labor class, the working class, specifically those who are migrant laborers who have to travel for work, for money, they don't have the necessary information to discuss and deliberate. They just work. You give them orders, they work. Now understand, they are people as well. Hard मांस से बने हुए इंसान है वो. So they are people as well. Even they are citizens of India. They come under the purview of persons. So they, even though they don't have the information, still their fundamental rights are protected under the Constitution. So bring up some mechanisms, some relaxing provisions, or some additional complementing mechanisms to supplement the already existing relaxation of labor laws. So if you have relaxed the labor laws for the benefit of the economy, bring in some mechanisms for the benefit of the working class as well. Otherwise, if it continues like this, it is not reasonable, it is not justified, right? So that is something I would like to conclude. I would like to conclude with this. Yeah.
I think on that note, I would like to thank Ritwik for joining us again and sharing his wonderful insights on labor law and the dilution of labor laws in various states through ordinances. I think you've touched every aspect possible with relation to the previous codes that were there and with relevance to the ordinances that have been brought out in many states and how it changes the economic conditions, how the quality of life of the workers are affected, and also brilliantly summed up the judicial precedents that are involved, like the Bandhuwa Mukti Morcha case, then the Maneka Gandhi case, etc. And on that note, I would like to thank you for joining us once again, and we hope to see you again soon in another informative and a very legal-oriented session.
This current episode, the full length, will be available on YouTube, and also you will to find the latest updates about the session as well on Instagram and other platforms as well. So do like, share, and subscribe to our channel on YouTube, and also follow our Instagram page with regard to regular updates as well.